May it please the court. Your Honor, my name is Dan Clay, and I represent the courageous young student challenging this motion to dismiss. Now, really what you just heard from defense counsel was that this case should not be held on the merits simply because it was just what the school thought was the easiest thing for them to do. But, Your Honor, this case isn't about what's convenient for the school. It's about protecting the rights, specifically the rights of Ms. Ringwald and students similarly situated. In furthering this, we will show that Ms. Ringwald maintains a valid cause of action for which relief can be granted against the school. Specifically, we'll show that the wearing of the headscarf is non-expressive conduct that is covered by the First Amendment. We will then further address that the defendant's dress code is unconstitutional under the First Amendment. So if we turn to the first issue that we raised in our brief, which is the scarf as nonverbal expression. As the defense counsel pointed out, this is a two-pronged test that was established in Texas v. Johnson and then later in Spence.
Isn't there a big difference between using something like a flag to protest versus using an untraditional, in color and manner, worn headscarf?
Your Honor, I don't believe so. Because as I believe it was as Kennedy told us that something like clothing can be endowed with certain messages, intentional and unintentional. So really, it kind of makes it no different than a flag, which is nothing more than a symbol. So when you have the symbol, the really one of the first tests you have to look at is the intent to convey a message. And while defense counsel has conceded this, I'll just touch on it briefly. As we learned in Texas v. Johnson, intent to convey a message is largely determined not only by the person's sworn testimony, but as well as evidence and the situation in which it happened. In this case, it's similar to Texas v. Johnson, in which he burned an American flag at a political convention, because the court held that a political convention is a place where ideas are meant to be exchanged, similar to that of a school. Furthermore, Ms. Ringwald on several occasions made comments to their students as to why she was wearing the headscarf, which would kind of show her that it wasn't necessarily just a fashion choice, but rather she was intending to convey a message. Furthermore, she would only wear it during school hours and not at home, so which implied that the headscarf was to be worn for her classmates, not for the world, not for a fashion choice. Moving on to the second prong, which is the message would likely be understood. Now, Spence tells us that in order to receive protection, the message has to be understood, but we don't have to understand the direct message. Rather, in Spence, the court alluded that only the general drift of the message had to be understood. For instance, in Spence...
So thinking about the Spence case, isn't it much easier for people to understand that a peace symbol on the flag, on the American flag, means America stands for peace, versus your client's scarf that means I like my friend? I mean, there's such a difference.
Well, I wouldn't know if I would agree with that, Your Honor. It seems more of a contextual, and that's what Spence tells us. It's really largely based on the context of what was occurring. For instance, Americans would understand that America stood for peace because when he hung the flag outside of his window with a peace symbol on it, it was just after the Cambodian invasion. Whereas here, if we take a look at the surrounding circumstances, not only do we, as we discussed earlier, the proximity to the 10th anniversary of September 11th, but the school had been hypersensitive to kind of topics of racial and religious inequality, especially considering there were several reported incidences in which the plaintiff's friend was bullied because of her religion. In addition, since it was just for the intimate school environment and not for the public as a whole, the students would be well aware of the plaintiff's personal beliefs, specifically her church attendance, which was a Baptist church, where you wouldn't normally wear a traditional headscarf, as well as her intent to go to Baylor, which is a conservative Baptist university.
Well, my understanding is that some students thought she was wearing a costume, they thought she was supporting terrorists. They seemed to be directly misunderstanding her message.
Your Honor, I don't know if I would agree with that, because Spence tells us that the message does not have to be understood 100% as it's to be conveyed. Rather, Spence told us that it was only the drift of the message which needed to be understood. So in this case, while we have to look at what the students said that might indicate that they didn't understand it, we would argue that it may be because they disagreed with the message, and kids being kids, that was their avenue to express their discontent with the message. Or furthermore, they understood, as one note that was passed asked her, how can you support Muslims after what they did on 9/11, which to us seems like they understood the drift of the message, in the very least. Because, again, my client was really trying to push not only support for her friend, but also show others that Islam was one of the world's great religions. And so just kind of the evidence that we have suggested, especially the note, shows that students did have an understanding of the message that she was trying to convey. So then our next challenge is that the dress code was unconstitutional. The US v. O'Brien established that the government can regulate speech only when it satisfies, the regulation satisfies, 3 prongs. Specifically, the speech has to have a legitimate governmental interest.
Which one do you think is your strongest argument?
Strongest argument, Your Honor? For the purposes of today's motion, I would say that our strongest argument is that it does not, the school does not show a legitimate government interest. Because, as we learned in Palmer, that the interest provided has to be more than just deterring minor disruptions. Such are the case that the defense cites here, that there was some conflict as far as exchanges in the hallways, things like that, which the court in Palmer really kind of indicated would be a minor disruption and not a legitimate interest. Furthermore, Palmer also said that the interest has to be stated by the school. In this case, the dress code didn't say anything as to what their interest protected was. All the dress code said, and I believe it's Exhibit D, all it said was the school would like to encourage students to dress in business attire. Not really ever saying...
I think the Palmer case specifically says that that's a valid interest.
It's a valid interest, but more so it has to be testified to. There has to be some evidence that the dress code is trying to further that interest. Thank you, Your Honor.